start with planning for incapacity. And we talked, and some of the questions were, what happens if you become incapacitated? What happens to your horses, right? You don't have a power of attorney, a document called power of attorney, financial power of attorney. And what happens is somebody has to go to court to get a guardianship over you, guardianship of the person and guardianship of the estate, to be able to handle financially and to be able to handle your personal stuff. But if you have a power of attorney, you've got that in place for who can handle those things for you. And so when you're dealing with incapacity for health care, it's the same thing. You have somebody enlisted as an agent who would be able to handle your health care decisions if you can't make them yourself. Okay? So that's what we talked about. So we're talking about the health care directives. The living will advance directive is where you create a document where you say, I don't want to be hooked up to a life support system in certain situations. So, do you remember the Terry Schiavo case back in 2000 in Florida? A lot of the documents were drafted because of that case, where you had the parents who wanted to keep her alive and the husband that didn't want to. And they went all the way to the Supreme Court. So the living will makes your wishes clear in those situations. And then healthcare power of attorney, we talked about, you name an agent who can handle and make decisions for you regarding your health care. So if the doctor needs approval or consent for someone to have surgery and that person can't make those decisions, then the agent is on the hook. Not on the hook, but has the authority to make those decisions. And you name somebody that you trust to be able to make the right decision at the right time. And then we have, a lot of the healthcare documents, healthcare power of attorney deals with the disposition of remains. So the agent in North Carolina is the first person who has the decision-making authority to handle your remains, whether you want to be cremated or whether you want to be buried. I had a client one time that when he had to make a decision, he said, but I don't want that to happen after I've died. So you have to joke about these things because you don't want to, these aren't fun things to talk about, so you kind of have to lighten things up. So I've always used that ever since. It's like, I'm going to make sure that only happens after I've died. So. Financial management, we're talking about that if you don't have power of attorney and you become incapacitated, the court supervised guardianship or conservatorship, depending on which side you're on, which state you're on. Time consuming, expensive, and embarrassing. So you want to make sure you have these documents in place so that you have somebody that you trust that can make the decisions for you. So other ways to plan for incapacity. Now you can't do this with horses because you can't really jointly own a horse. I guess you could husband and wife. Okay, so you can jointly own a horse. So then you could have that's a planning tool. Okay. So joint ownership has access to the property you do. So think of a bank account that's joint with rights of survivorship, and each person has the authority to make the decision. With horses joint ownership, then you can make the decision. Okay. We have the durable power of attorney lets you designate an agent to make the decisions on your behalf. So if you're determined to be incapacitated, or if the financial power of attorney specifically says that the agent has the authority upon signing, so in other words, the agent has the authority at all times, then that agent can make decisions for you, financial decisions, can sign contracts for you as your agent, and can sell things and buy things. So obviously you want someone as your agent that you trust to make the right decision at the right time.
I have a quick question, that
Sure.
might be a stupid one, but what's the difference between a power of attorney or durable power of attorney?
They're the same.
They're the same thing?
Yeah, it's essentially the same thing. Yeah, you think of a durable power of attorney as a financial power of attorney. It's durable upon your incapacitation is what it means. It's basically what it means. So I always distinguish a durable power of attorney and a healthcare power of attorney. And we use two different documents. Some people don't, but we use two different documents because a lot of times you want different agents to handle different things. You want different people to be different agents.
And does something like that have to be notarized? Can it be just on a piece of paper and then just notarized, or?
You're going to want to do it notarized in front of witnesses as well. Yeah, yeah. And then a living trust, and we'll talk about that a little more. The living trust is it's a revocable living trust that allows you to avoid the probate process, essentially. And when you put things into the trust, I'll go into more detail about that in a second. But when you put things into the living trust, instead of having your agent under your power of attorney handle things, the successor trustee is the one that handles that. Okay. And And you don't lose any control when you create a revocable living trust. But it's just a way to avoid the probate process. So, the 60+% that don't have a will, I think the misunderstanding or the misnomer is that the state gets it, which is not true. When I was in law school, I was 38 when I graduated law school, so my second year in law school, my son was just born, so I had a 3-year-old and a newborn. And I took a wills and trust estate in South Carolina, and always thought that if I didn't have a will, which I didn't at that time, that everything would just go to my wife. Took the wills and trust course, wills and trust and estate, and learned that under South Carolina law, my kids would be, under the laws of intestacy, would also inherit some of my assets. So we quickly got a will. And one example, in North Carolina, husband died in a tragic motorcycle accident, didn't have any children, had a wife, his mom was still alive. After a $100,000 distribution to the spouse, the mom and the spouse split everything, and that's under the laws of intestacy in North Carolina. So the state of North Carolina and the state of South Carolina will make a will for you if you don't have one, is basically what the laws of intestacy are. Not trying to scare you, I'm just saying. So when you don't have an estate plan, you don't name who you want to be your beneficiary, you don't name who you want to handle your estate as the executor, the court appoints someone for you. So you're stuck with what the state says. So the will is the cornerstone of the estate plan, okay? I think everybody knows what a will is, right? It directs where you want your property to go, names guardians for the kids if you have children, names the personal representative, which is interchangeable with an executor. So you name who you want to be in charge of administering your estate. And you can do other things, deal with estate tax planning, and you can create testamentary trust. And you think of a testamentary trust as done under your last will and testament. That's where the testamentary part comes from. So you can create trusts inside of a will, written, signed by you, and witnessed and notarized. All those things. Okay? Talks about probate. Personal representative is the one that collects the asset, pays the debts. I think we were mentioning that the mortgage on the house and the car loan had to be paid off. But that's essentially what happens, right? All the debts have to be taken care of before the beneficiary gets anything. And that's what the probate process is. The government still needs tax returns, still requires a tax return even after you've died. So even, we're in August, we're almost in August now. If I were to pass away in August, I'd still have to file a tax return. I wouldn't, my executor would, right? So they still have to do all that. That's the probate process. And typically probate lasts at least a year because you're going through the court. In North Carolina, there's a 3-month period of time to run a notice to creditors in the paper. In South Carolina, it's an 8-month period of time. So when you're notifying creditors, you're running a notice in the paper, and they have a certain period of time to file a claim. And it's 3 months in North Carolina and 8 months in South Carolina. So in South Carolina, it's at least 8 months of probate process.
Do you still have to put a notice of death in the newspapers in some states? My
It's a
mother
notice.
just died and my brother's handling it, and he said you don't have to do it anywhere because now it's the burden of the people that, because there's the internet, it's the burden of the lender that to know who's died and who hadn't. You don't have to put it in the paper anymore. He just put my mom's obit on the funeral home. He said that's all he's gotta do.
What state?
Florida. And he's from Idaho, Texas before then. Thinks he knows everything. And I said, you have to put it in 3 different papers. No, you don't, not anymore. I'm like, okay, whatever.
Well, I think Florida still has a notice to creditors, period of time. Okay.
Florida lawyers, yes it does.
I know that North Carolina and South Carolina do. The purpose of the notice to creditors is to put a creditor on notice that they have, to let the executor know they have a claim. In both states, North Carolina and South Carolina, I'm not speaking on Florida, I'm gonna turn to you to let you speak about Florida. In both of those states, you have to notify the creditor if it's a known creditor. So you can't get away with saying, you didn't file a claim. But it's a process. And if in North Carolina, if you don't file that notice to creditors, they can come back over a 3-year period of time, they being the creditor, and file a claim. If the creditor, which you did not know about, did not file a claim within the 90-day, 3-month period of time in North Carolina, they're forever barred. So it's almost like an insurance policy.
But you have to put the notices in papers.
It runs 4 consecutive weeks in North Carolina.
Yeah.
I
Yeah.
But yeah, and then you may wanna ask your brother again.
No.
No.
So if you've got all these documents and they're filed in one state, and you move to another state, say here, does that paperwork follow, or do you have to redo it all?
So, this came up earlier about filing a will. You can file a will with the court. We don't. So your will, if it's, let me see if I get this right. If it was validly done, it was done validly in the state in which you moved from. Are you in South Carolina or North Carolina?
I'm in North Carolina and the will was in California.
So if the will was done properly under California law at the time, the North Carolina will honor the will. That being said, I recommend you update your plan.
I mean,
I recommend that you update your plan. Just, I mean, but yes, it's likely if it's a valid will under California law. Now, the filing part, I don't know the answer to that one. So if it's filed with a court in California, I assume you pass away here, there's a process for getting that will over to the court here.
do you recommend, every 5 years to revisit your will,
3 to 5,
3 to 5?
and if anything changes, like divorce, children, those types of things. Yeah.
Or is-
If you have this paperwork done and say you keep it in the bank box, you pass away, how can the attorney, or not really the attorney, but,
It's tough.
the executor, do they have the right to use your keys to get into that, to obtain your will and your,
You gave our kids keys.
I'm sorry, please?
Our kids have, they know exactly where everything is and they have a key to the.
Safe deposit boxes are tricky.
Yeah, oh.
Sometimes the clerk in North Carolina has to go to drill the box, or to open the box, or someone has to be there to inventory it. They're tough. That's one of the questions I always ask when we go over bank accounts. Do you have a safe deposit box? How's it titled? What's in the safe deposit box? I always do, I try not to discourage people from having a safe deposit box, but it's difficult to deal with after someone's passed away. For what it's worth. Good. Pros and cons with wills and probate. Pretty modest cost to do a probate. You know, some states are much better than others. You know, I screwed up. Sorry. In some ways, there's a pro and a con for court supervision. I mean, having the court, whether it's the probate judge in South Carolina or the clerk in North Carolina, having them oversee it is probably not a bad idea. But we as estate planning attorneys always preach to avoid probate. I always try to say minimize what goes through probate, because I do think it's a good process. So I put that in the pro. Protection against creditors, we talked about the notice to creditors. And that's why, even if we do trust-based plans, I still encourage executors to run that notice to creditors, because it's protecting the executor. Because if you make distributions to beneficiaries and then a creditor that's a valid creditor comes forward and says you owe the person that died owes $10,000, and there's nothing left in the estate, and you distributed over $10,000, guess who's on the hook for that $10,000? The executor. Yeah, person liable for that, for a wrongful distribution. Yeah. I'm not here to scare y'all, that's not what I'm trying to do, I'm just kind of giving you the facts. Cons, it can be time consuming. So with probate, in North Carolina especially, you have to file bank statements. You have to show the clerk what goes in, what comes out, what's paid. It can be cumbersome. And that's why we talk about revocable living trust, because it avoids that whole thing. So even though it's pro is court supervision, it can be a con. I don't know if I put it on there. Title transfer delays, fees, court fees, even though it's modest, but still there's fees. And ancillary probate. Anybody know what an ancillary probate is? So who has land, who has real estate in another state different from where you live? Okay. If the real estate is owned solely in your name, not like joint with rights of survivorship or husband and wife, and you pass away, say you're in North Carolina and you own a beach house in South Carolina, right? You're gonna have to do 2 probate processes. Well, you're not, because you're not here, but your executor is gonna have to do 2 probate processes. You're gonna have to do a probate process in the state in which you live in North Carolina, and say you have a house on the Isle of Palms, then you have to do a secondary probate process in Charleston County. That's called an ancillary. It's a secondary probate. And you want to avoid that. That's where revocable living trusts come into play, because if you title the real estate at Isle of Palms into that trust, you don't have to do that secondary probate. With the same formalities that you had to do in North Carolina, well, in South Carolina, but run the notice to creditors and all that stuff. Oh, the other thing is the will and the estate file. You can walk into any courthouse in either state and see exactly what was in that estate file. You can request an estate, you can go look at who the beneficiaries of the will are, what the accounts were, it's all public record. And pretty soon, North Carolina's gonna go online. You know, all the register of deeds, you can pull deeds in most counties in North Carolina now. In about 5 years, you're probably gonna be able to do the same with estate files. They're having some pilot projects in a couple of counties, 2 counties, 3 counties in North Carolina for online, which is gonna be great, but it's also gonna be easy access, public records. So one of the benefits of not doing probate is it avoids the public record part. So you hear all these famous people like Prince who have just had a will, they didn't have trust. Actually, I think Prince died in testate. But some of them, you wonder why they didn't have a trust, because nobody would have known anything about what they had.
Can I remind you tomorrow?
Yeah.
So Gina's computer.
It's there, so.
Oh, it's theirs?
Yeah.
Oh, it's yours. And you can avoid probate a couple of ways. Join the rights of survivorship, even with horses. Come on, laugh.
Yeah.
Beneficiary designation forms for IRAs, life insurance policies, annuities. Don't make your estate the beneficiary of any of those, please.
Why not?
Thank you. If you make your estate the beneficiary, then it pays out to your estate. And you don't want it to go through your estate. So if you have a trust, you can name the trust. IRAs are different, we'll go over that in a
Does it go
second.
through probate?
It does go through probate. The court oversees it. And sometimes the default on those is that it pays to the estate. If you don't have it, you haven't filled out a beneficiary designation form, the policy, say a life insurance policy, it's all in the small print. They will probably say the default is it's payable to your estate. Because the life insurance company, the safest thing for them to do, if there's no beneficiaries, to pay it to the estate and let the executor deal with it. Then it's cumbersome. If you name your children, or your best friend, or your wife, or your husband, or whoever, they just cut a check to that person, and the court's not even involved. Just get a death certificate, they cut a check. Transfer on death. More transfer on death accounts. I don't know about the deeds. I'm not sure why I have that in there. But transfer on death or payable on death, you could do that to your accounts where you name a beneficiary of a checking account or a savings account or an investment account. You can do that.
That doesn't become your estate?
It doesn't unless the executor needs that to satisfy creditors. Same with the joint rights of survivorship account. So the executor has the authority to go after that account if the executor needs it to pay debts of the person who died.
So that may have answered would you say that again?
So if you have a transfer on death designation, so there are two, go ahead.
Well, my question was a similar question for, when you have a properly designated beneficiary for, say, an IRA. You know, how do those assets play into, you know, debt payment in the probate process?
So with IRAs, so what she's asking is, you have an IRA or a life insurance policy, and you've named your children as beneficiaries of either one. Can the creditors reach those? Is essentially the question,
Yeah,
right?
basically.
Right. For life insurance, if it's a family member, then it's creditor protected. So the creditors cannot reach that. We had a case where someone passed away, he had a significant amount of debt and had a surviving spouse, but he had a large number of insurance policies. Those debts went away. The insurance policies paid to his surviving spouse, and she didn't have to pay any of his debts. Right. pretty sure are as well. I know the 401ks offer more protection than the IRAs do, but I think that they're protected as well. But I think I know jointly rights and survivorship accounts or TOD accounts are subject to the creditors. And then lifetime gifts avoid probate, but who wants to give away their stuff, right? Use trusts. So we talked about revocable trusts. Can protect against incapacity. So it acts like a power of attorney would, because you have incapacity provisions in the trust itself. So you think of a trust as a contract, and in that contract you've laid out who the beneficiaries are after you've died, what happens if you become incapacitated, who takes over, what that successor trustee is the person who takes over. Because the trustee, you think of a trustee as someone who owns the property from a legal standpoint for the benefit of the beneficiary who's named in the trust. Make sense? Good. So from that standpoint, it has its own power of attorney built in. So it states in there, if you, as the maker of the trust, are incapacitated, then John Smith is the trustee, if you name John Smith as the trustee, right? John Smith steps in your shoes and handles all of the assets and continues to pay bills, but only for you, for your benefit. He has a fiduciary responsibility to make sure that all the assets are for you to maintain your lifestyle, to pay your debts, to pay a mortgage, all those types of things. It avoids the probate process. If everything's titled in the name of this revocable trust, we talk about bank accounts, right? If you retitled that into the name of the trust, then it doesn't have to go through probate. It automatically, the successor trustee takes over.
But in order for a distribution to take place, let's say a bank account with the beneficiary designated, does it have to wait the 8-month process in South Carolina?
So the question is, if it's owned by the trust,
Right,
either
it
way.
doesn't go through probate,
Yeah.
does it still have to wait the 8 months?
So the question is, if it's in the revocable trust, right, are the assets in that revocable trust subject to the person who died's creditors? Is that the question?
Well, not necessarily accessible, well, I think that's actually preliminary. So let's say they're assets that are accessible to creditors. Let's say it's an IRA and we don't know whether that's protected from creditor. Does distribution under the IRA have to await the 8-month creditor notification process?
The IRA will be transferred immediately. It's not required. So the question is, does the IRA have to wait for the 8-month period in South Carolina for the creditor's notice? No.
Right. Okay.
The trust does. The trust should. So if I'm representing the trustee, I'm telling the trustee, do not distribute any of the assets to the beneficiaries until this 8-month creditor period has ended. Because the trustee is still subject to those creditors, the trustee of the trust. So the trust that we've done, this revocable trust, does not give creditor protection to the person who made the trust. Make sense?
So you don't want to put protected investments in a trust.
Tell me what a protected investment
Like an IRA, if you
Correct,
consider
no.
to give a direct beneficiary to your kids, don't
No.
put it in the trust.
Well, you can't really you shouldn't put it in the trust anyway, but you could name the
Right.
trust as the beneficiary.
Correct, okay.
Okay, good.
So, I have a question. So if you have to wait 8 months, and if you become incapacitated, can you access this money to take care of horses or?
Absolutely.
Okay.
Yeah, and in our documents, what we do is when a person dies, the trust goes from being a revocable trust to an irrevocable, we call it an administrative trust, because it administers the trust and estate. And so all the assets that get moved to this second trust called an administrative trust, at the time are to be used to pay court fees, because we'll still run that notice to creditors, to pay CPAs for tax returns, to manage real estate, to manage the assets, which include horses, which can be owned jointly. But if it's in a trust, it's not jointly owned. So those assets can be touched and can be used to pay those expenses. Because the idea, if you own real estate, say the Isle of Palms house, right? And the trust person dies, Somebody's gotta continue to pay those homeowners association fees or the flood insurance or whatever. And that's what that trust does, it continues to pay those expenses.
So what's really the difference between this and a will?
Well, if
It
you have,
sounds like it's both the same.
so the court's not overseeing it when you're in the trust. The court's not overseeing everything that you're doing when you have a trust. So whether it's the probate court in South Carolina or the clerk of court in North Carolina, you're not having to get approval from them to pay these expenses. And there are weird laws in North Carolina about real estate.
So don't have a will, have a trust?
It just depends. Isn't that what all lawyers say? It just depends?
Yeah.
Yeah. I know you can't commit.
No, I mean, so the question is, should everybody have a trust? No.
So when do you have a trust and when do you have a will and when do you have both?
So if I'm meeting with clients, a husband and wife, and they have $1 million in an IRA, and they have a bank account that's owned jointly with about $30,000 in, and they have a house that's owned jointly, I'm not gonna put them in a trust. Because the IRA, we name the surviving spouse, whoever's IRA is, as the beneficiary. All the other assets are jointly owned. So in my mind, the goal is to be as easy on the surviving spouse as possible. Have everything jointly owned. When this first spouse dies, then we can talk about whether we want to put that in a trust at that time. Because a trust costs more anyway at the beginning. Costs more to set up. So no, I don't put everybody in a trust. Even though I'm telling you should right here, I guess. And again, you can name, when it says allow professional management of assets, you can name a corporate trustee to handle things, if you wanted to. That's what the professional management. Control over property, although when you have a revocable trust, you don't lose control over the property at all. You know, I think about, that's what I tell people all the time. You create a revocable trust, you lose no control whatsoever over the property. But you don't get any creditor protection either, so it's not protected from your creditors. And then the privacy is a big thing for people, because the stuff that's in the trust after you died, it's all private. It's a private document. You can't walk into a courthouse and see information about, most of the times, about a trust. Okay? So I think we kind of went over what a trust is, right? The trustee, a grantor is the same thing as a trust maker. You have a trust agreement, you have trust property. The trustee is the one who manages the trust, is who's in charge of it. So if I'm doing a revocable trust for you, you're gonna be the trustee of your own trust until you either pass away or you become incapacitated. And you've got a list of people who would be your successor. And then what happens if you become incapacitated and what happens at your death. So you have a living trust and testamentary trust. And I mentioned earlier, testamentary trusts are done under your will. So you can create a trust under your own will. And you have revocable trust and irrevocable trust. And we can go over that in a little bit. And then you have pet trust for horses and for animals. Both states allow for pet trust. You can create a pet trust under your own trust, put money in it, and say what is to happen to your animals, whether it's any type of animal. Now the pros and cons of the revocable trust. The pros are avoid probate, privacy, reduces administrative burden on the loved ones because it's supposed to be a lot quicker. Cons are it's more complex, more work up front because you're retitling the assets, and higher initial costs. Costs more to set up a trust than it does a will because there's a little bit more work to do. Pet trust. So the benefit of the pet trust in my mind is that what you can do if you don't have a will or a trust, right? Then we talked earlier about the horror stories about what happens to the horses when someone passes away, right? They're sold, they're mistreated or whatever. You specify in your own document, whether it's through your will or through your trust, what's to happen to your horses and who's to be the guardian or the person who takes charge of the horses and who the trustee is. So what I often do is we talk about, I think that it was mentioned $1,000 a month for boarding, right? So we think about how much it costs over a period of time to continue to take care of your horse or horses. And then so I have an idea that you put a certain amount of money, $100,000 into this pet trust. And you've got a person who's the trustee, and you leave instructions for that pet trust of what that person is supposed to do. And they're required, they have a fiduciary responsibility to follow through with that and can be sued for mismanaging that. Okay? In both states, South Carolina and North Carolina, you have it so that the trust terminates upon the death of the last surviving animal. So if you have multiple horses, that trust can continue until the death of the final horse, the last horse. Okay?
What happens to any money that's left over?
You specify in there what happens to it. The different beneficiaries, or it can go to foothills, or you specify what happens, and the trustees are obligated and responsible to follow through with that. Yeah.
We have a thing in our will that's, in our will, that's basically like this, that we figured out a certain amount of money, and from our estate that would go into an account managed by a person that we've designated. And then if there's money left over, it gets distributed to the other beneficiaries, whatever's left. But I knew it was the other kids, is that enough to have that in the will, or do we need specific pet trusts?
Well, it sounds like you have a pet trust. It sounds like it's a testamentary pet trust, because you've created
Okay.
something inside of your will that says this amount of money goes to support the animals.
So it should be.
But the problem, the difference between doing a trust, a revocable trust that creates a pet trust, and the will that creates a pet trust is there could be a longer delay through the will. Because you have to go through probate, you have to get it appointed as the executor of the estate, and then the money has to, it's a longer, there's more red tape, maybe is a better way to say it. Whereas if you did it inside the trust, then the trustee can immediately create that pet trust and move the money if it's easy access to the money.
Could you do like a codicil to an existing will of trust?
Could you do codicil to the will to create a trust? Sure.
Do a pet trust?
Sure.
Okay.
Yeah, codicil is just an amendment to a will. It just changes it. Yeah. I always joke, I say you can do a codicil, it's just a fancy way to say an amendment to a will.
Okay.
Yeah, so it's just you amend the will. So. Good? The other thing with the pets also, just going back real quick. If you're incapacitated, right, and you have a revocable living trust, what we do is we have a document where you assign all of your personal property to the trust, right? So we would assign animals and all those things to your trust. So if you become incapacitated, the way I would deal with it is the successor trustee, your incapacity trustee, would then be in charge of taking care of your horses and making sure that your horses are properly taken care of. If you don't have a trust, then your power of attorney, your durable power of attorney, your agent under that power of attorney, also called an attorney in fact, would be the one that's in charge of that. So that some of the questions about Alzheimer's or whatever, when someone has that, how are the horses taken care of, that's what these two documents do, whether it's a revocable living trust or a power of attorney. Your agent, attorney in fact, under power of attorney, or your successor trustee is the one that's responsible for properly taking care of your horses and making sure that they're healthy and everything's great with them.
And the pet trust does not do that, right?
So you can create a pet trust now, and that accomplishes that. But I typically don't create the pet trust until after someone has died. So what I typically do is, I mean, I hate to even say it, but the horse is owned by the trust, right? It's not jointly owned, it's owned by the trust. So then it's essentially property, like we said earlier. It's an asset. So then the trustee is responsible for maintaining that asset and taking care of that asset. It's terrible to think of a horse as an asset, but some of us do, because it's not cheap. Or it, she, he.
Yeah, what is liability?
Liability, right. So are cars are liability, right? Yeah, but so that's the way it kind of works. I mean, if you become incapacitated, you want to lay out how you want your horses, or, I don't own a horse, but I have a dog and I won't tell you how many cats. So we want, how many people, you want to make sure that they're properly taken care of. We met with someone today and she said, they're more important to me than any other assets. My dog and my 2 cats.
Yeah.
They're more important than anything else. And I don't know that I disagree. So you want to lay out how you want your animals to be taken care of. Who asked about taxes? on taxes now. I was gonna skip over this, but I'm kinda go over it. So you have gift tax, you have estate tax, and you have generation skipping transfer tax, and I am not gonna go over GST. Alright? If you think of a gift tax and you think of an estate tax, they're the same. You have a certain amount that you can give away during your lifetime and at death. If you give away that amount at your lifetime, it reduces what you can give away at your death. Okay? Used to be much more, we used to plan much more for that than we do now, because it used to be as low.
What's the max now? It used to be 10,000.
Used to be what?
10,000.
So you're talking about annual. You're talking about what you can give away annually. This is estate tax. You tell me if I'm going too in depth here.
No, you're.
How are we doing on time? Everybody ready to get out of here? So estate tax, so you're looking at the 17 through today, right? In 2017, the estate tax was 5 million indexed for inflation. Then the Trump tax cuts came forward, and he doubled it. So it was 10 million indexed for inflation. This is per person. And what that means is that's what you can give away during your lifetime or can pass at your death. So it was 10 million indexed for inflation in 18, which meant it was 11.18, and it went to 11.4, 11.7, now it's at 12.06. And next year it'll be, who knows, 12 point something, okay? I'm not going over the GST stuff, but if anything above those amounts are taxed at 40%. So you die this year with $15 million and $15,060,000, because the 60,000 still is. And you get taxed 40% on $3 million.
So that's the federal level. What about the state level? North Carolina or South Carolina?
No state estate tax.
There is no estate tax in North Carolina?
No
or
state estate tax.
In either state?
Correct. They've repealed their state estate tax. Anybody from Massachusetts?
I was from Maryland.
In Massachusetts, it's a $1 million exemption. And if you're over $1 million, you're not taxed above the million, you're taxed on the full amount.
And Maryland is that way too?
Is it? See, I don't know Maryland.
7%.
So some states do have a state tax, but North Carolina and South Carolina do not. So again, you can give away, who's the next to 10,000? 16. Yeah, it increased for last year from 15 to 16. It was 15 for probably 6 years. What that means is you can give away $16,000 to as many individuals as you want. It's called an annual exclusion, without notifying the IRS of that gift. Okay.
But then that has to be reduced from the total of the 12
Nope.
million? No.
Nope. It's not. It's a free gift.
Okay.
Free gift in more ways than one.
You can also do a loan and a revocable retreat. I can't think of the word. Forgiveness.
You can.
Can't.
Yeah, and you can also, if you, gifts for education and medical expenses. But remember, the 12.06 applies to it, so anything above the 16 per year does reduce your exemption. Okay, so you have 4 children, you could give away $16,000 to each of the 4 of them. If you're married, you could each give $32,000 to each of them, and not have to notify the IRS. Have to file a gift tax return to let them know, but I guess you have to notify them, but it just doesn't reduce them. One of the drawbacks of gifting something to someone during your life, say you give away $1 million house on Isle of Palms, just to be consistent with all the examples, right? If you give it to your kids, they take the basis in that asset. In other words, the basis is still what it was. So if you paid for that house 10 years ago, you paid $500,000 for the house, and now it's worth $1 million. You've got a $500,000 gain. They continue to keep that $500,000 basis, so if they sold it, they'd pay gains on that $500,000 difference. So that's a drawback about giving gifts away during your lifetime. If you held on to it at your death, the basis goes away, and the kids would inherit that, and the basis would be what it was on the day you died. When we say step up in basis, that's what we're talking about.
What about if it goes to trust?
To a revocable trust?
Right, revocable trust, is there a step up?
Yes. Yeah. As long, if it's includable in your estate for estate tax purposes, then it gets a step up in basis. Now, does anybody know whether an IRA gets a step up in basis? It does not. Because IRAs are deferred taxes. So anything in the IRA, a beneficiary, and I'll go over the IRA in a second, the beneficiaries still have to pay taxes on that. There's no basis in it. So that's the 16,000, 32,000 if you're married. For a 529 plan, you can give away 5 years tax-free. No gift tax paid directly to the school for an individual's tuition, or directly to medical care for an individual's medical care. And then you can give away as much to charity. You don't pay gift taxes on gifts to charity. Kind of beating a dead horse here. That was bad, wasn't it? That was the wrong place to say that. We're going over the same thing. I didn't mean that. That was bad. So, with the estate tax exemption at $12 million, if you're married, you double that. So married couples get a $24 million exemption. Only married couples. And there's a thing called portability. You can use an unused. If you guys want to know more about that, we can talk a different time for that. I don't think that's big right now. But there's a thing called portability. But $24,120,000 can be left to beneficiaries tax-free in 2022 if you're married. I don't know. Secure Act. Anybody heard of the Secure Act? So years ago, for years, when you inherited an IRA, so you know IRAs, traditional IRAs, you not pay taxes on. And if you're 72, it used to be 70 and a half. If you're 72, now you have to take a required minimum distribution on an annual basis, right?
Mm-hmm.
And you're taxed on that, right? So you pay taxes on that distribution. If your spouse, if you name your spouse as a beneficiary of the IRA, the spouse just rolls that over into his or her own IRA and continues taking those required distributions based on his or her own life expectancy. If that person is 72 or older. It used to be for non-spouses, for children. Think of your children. You've named your 2 children as beneficiaries of your $1 million IRA. So they each receive $500,000 of money that has not been taxed. It used to be that they could take required distributions every year for the rest of their life. So small little distributions, we call that a stretch out, for their entire life. But they could take it all out at once if they wanted to. So anything they take out, they pay taxes on. When the Secure Act passed at the end of 2019, that got rid of that. So now if you have a large IRA and you have a non-spouse as a beneficiary, not a charity, but a non-spouse, that person who's the beneficiary or people have 10 years to take that out of the IRA and pay taxes on. So that's what that means.
Okay,
Good.
so can you repeat that? So if you are 72 and you do not take it out of your IRA and you transfer your IRA to your younger, no? Okay.
It only applies at your death.
Oh, you're that.
Yeah. So at your death, you've named a beneficiary of your IRA,
I see.
right?
So they don't have to continue taking it out, they can stretch it out until
They used to be able to stretch it out. Now they cannot. Now they have to take it 10 years. Take it within 10 years and pay the taxes on it within 10 years. So you think of the IRA, the purpose of the IRA was for us to save for retirement, right? The pensions went away, so they started doing IRAs, and you didn't pay taxes on it. So you contributed a certain amount, you can pay taxes on the income that was
and now you
distributed.
have to withdraw a certain amount of money since you're 72 years old out of your IRA.
And that was always there. It used to be 70 and a half.
Right.
It was 70 and a half. They
Okay.
increased that to 72 with the
Okay.
Secure Act.
Mm-hmm.
And then it used to be that the next generation could then stretch it out for their lifetime. Now they've taken that away. The next generation, or whoever the beneficiary is, has 10 years to take it out. unless that beneficiary is a surviving spouse. Make sense?
I'm confused, but that's okay.
We can talk afterwards if you want. Okay. But it was a scrap, it was a huge law that was passed, I would say a huge surprise. We didn't think it would be passed. So. If you died before 2020, not you. If someone died before 2020, then that beneficiary can stretch it out. It applies to only those who have died 2020 forward. Yeah. Conclusion. We talked about planning for incapacity with horses. Again, that can be jointly owned. Looking at you. You have a valid will. If you don't, then the state that you live in will have a will for you. Transfer taxes, whether they're gift taxes, estate taxes, and does your overall estate plan reflect your wishes and circumstances? Any questions?
If I have a revocable trust, and right now there's nothing in there about my pets or animals, you do an amendment,
You can.
can't I just, if I trust my beneficiaries, just tell them what I wanna do?
You can, but they may not.
Yeah.
So, I don't know if you make it. Say again?
Well, then you have a new beneficiary.
Yeah. I mean, so in our trust, you have a section for tangible personal property, right? Your stuff. The legal term is your stuff. Not really, but that's what I call it. Then you specify who you want to get it, right? I think if you we put in there for animals, whether it's horses or dogs or cats or birds or whatever, how you want them to be treated and who you want to get them. And it makes sense to make it as clear as possible, but at the end of the day, it's probably sufficient as long as they'll follow through with what you want.
But what if you're incapacitated and they're paying for your care?
They can make the decision
They
to
have
sell.
to decide between you and the horses, maybe.
Yeah, I mean, the horses are pretty, you have horses? How many horses?
6.
How many cats I
But they're smaller, they don't cost as much.
Most of them, the instruction would be to euthanize them when they die.
Really?
Yeah, they're all retired, I wouldn't trust anyone to put them in the right place except to euthanize them.
Yeah, that's what.
I'm just trying to think if I would put that in a trust or not.
You get buried with your horses.
I do want my ashes thrown in the graveyard.
Yeah,
Did you ever?
there are 2 people buried in Polk County with the horses.
Are they really?
You talked a bit about estate taxes, but you didn't mention income taxes.
Mm-hmm.
And, I wonder if you could just briefly address the
That's fair.
differences.
But
Can horses be jointly? No. Income tax, the tax rate for, trust income tax.
wow, you're really getting deep here.
Well,
So irrevocable
It's a big
trust,
bet.
these don't apply
It's a big bet.
to revocable trust. Okay, so the revocable trust uses your social security number. So if you have a revocable trust now, any bank account, investment account uses your social security number. So it's basically a mirror image of yourself. Irrevocable trust, so you can leave assets to kids in an irrevocable trust that is protected from their creditors, divorce, and bankruptcy. What she's asking is that if you have an irrevocable trust, how are those taxed? How are the assets in those trusts taxed? The brackets are compressed, and what that means is the top tax bracket, you hit the top tax bracket of 37%, it's just over $13,000 worth of income. Where it takes individuals, married filing jointly, $600,000 to hit the top tax bracket.
The trust starts top tax bracket,
Irrevocable trust, not a
Yeah.
revocable
But
trust.
it becomes, the revocable
Irrevocable,
living
okay.
trust becomes irrevocable as soon as you die.
Right.
So it's, say these pet trusts that we're talking about, as soon as you die, it's in,
They start
it's
getting
in this
taxed at that high rate.
Which is
very
why
high tax bracket.
Which is why,
You go.
okay, which is why you get the income out of the trust. You use the income for expenses, you distribute the income if it's not a pet trust,
So you,
distribute the income to the
Net.
beneficiaries and let
Net,
the
not
beneficiaries pay the taxes on it at their lower rate. And you have you're getting really in the weeds here. You have 65 days at the end of the year to get income out of a trust. It's a 65-day window. So there are ways that you can do this for these irrevocable trusts. But you're right, it's a good question. There's somebody over there.
Hey.
Hey.
You have a beneficiary listed with your retirement account, and you have a will. And you set up a testamentary trust within your will.
Great question.
Which one supersedes?
Who's the beneficiary of is it 401k?
Say you give your IRAs, divide them amongst your kids,
Okay.
and in your will, you specify that you want them to take care of your animals.
The IRA is gonna go to the kids.
The IRA, the money goes to the kids.
Yeah.
And then whatever's left with your other assets.
Goes by way of what the will says.
Okay, so the will supersede, the beneficiary listed on IRA supersedes what's in the will.
Correct.
Thank you.
Same with life insurance. If you have life insurance, $1 million life insurance policy, and you've named your 2 children as the beneficiary, but your will says everything goes to charity, the kids get the life insurance. Yeah. Any other questions? I'll be here to, go ahead.
What does it typically cost to review your existing will and trust, just to see if it should be updated, or?
$100,000. No, it depends. So when I meet with people, I typically meet to go over it and don't charge for the meeting. And then I will more than likely recommend updating it unless it's, I don't typically review the plan though, the will. So say, it was done, are you in South Carolina or North Carolina?
We're in North Carolina, we moved from New York, we had it done, redone when we moved to North Carolina.
You did?
4 years ago, yes.
4 years ago. I hesitate to review somebody else's work. Maybe an hourly rate? I don't know, it just depends on the situation.
Okay.
Yeah.
Should they be reviewed
I
periodically?
think so, yeah. I mean, you're at that 3 to 5 year window.